Hi, I'm Bryan Drew, and I think I've done something that not many people in the state of Illinois have done, and that is I read all 764 pages of the Illinois Safety Act. Now, some of you might say you need to get better hobbies, but I practice law, I've practiced for 23 years, and I was concerned about it. So what I'm going to talk to you about today are some of my top concerns with the Safety Act. And let me tell you, if I went into all of the concerns, we'd be here for about 3 or 4 days continuously. It would be a longer video than anyone's going to watch. So what I'm going to talk about are just some of the top 3 really things that concern me the most. And basically, I would say the first one is the portion of law that I think the originators of the law have been pushing as the greatest thing about it. And I've heard the governor talk about it and other people, and they said, well, people accused of murder cannot be released from jail. And that's been the big talking point, that currently in Illinois, you could buy your way out of jail with a bond. Now, let's break that down. In reality, anyone charged with murder, their bond is usually way north of $1 million, which means you'd have to come up with between $100,000 and $1 million to get out of jail. I don't know many people that can do that. Most people accused of murder sit in jail until their trial. That's a fact under current law in Illinois. Under the new law, I think you're going to find out that it's a little more shocking than you think, because on the face of it, the way people have described it, everyone accused of murder must be detained, and they're detained until their trial. That's not necessarily true. What it says is that everyone accused of murder, or anyone accused of a crime where they must be detained until their trial, now the prosecutor has 90 days to try them. And if you do not try them within 90 days, guess what happens? They cannot be denied release. So how does this shake out? So somehow the prosecutors and law enforcement, who are already understaffed and overworked, have to figure out how to get a murder case ready for trial within 90 days, which means the Illinois State Police Lab, which regularly takes between 3 and 6 months to get back DNA evidence from them. Now, if they can't get it back to the prosecution, get it in the hands of the defense attorney, and ready for this case to be tried within 90 days, you shall release them. That's what the law says. I'm not making this up. It's legitimately what it says. That goes with everything. In addition to that, when you talk about pretrial release, there is a phrase that no one really knows what it means. I'm a lawyer, practiced law for 23 years, and I understand that prior to your trial, you can either be released or you're held out on bond. Now we're just talking about pretrial release, and the new law says that every person accused of a crime is presumed to be eligible for pretrial release. What that really means is they can't hold you in jail till your trial. They've got to turn you loose. Used to, they'd make you post some money. Now they say, well, we're not going to make you post anything. You're just going to be out. But my biggest concern isn't necessarily that. One of the biggest concerns is 2 things. One, what can happen at these detention hearings? So if an individual is accused of sexually assaulting a child, the defendant can ask at the pretrial hearing for the victim to be brought in. Now, it's in the judge's discretion if the judge brings the victim or not, but one of the factors in whether or not you can be detained is whether or not you committed the crime. So what we're going to have are little mini trials in front of a judge to determine, well, did they do it or did they not? And victims can be brought in. Some judges will say, I'm not bringing a victim in. What about the judges who do? That's a frightening situation for someone who accuses someone else of a crime or is the victim of a horrific crime. In addition to that, you have to have a specific identifiable victim, which means in the city of Chicago, they've had over 1,200 carjackings in the last year, which is twice as many as New York and LA combined. Currently in Illinois, those people aren't being detained. Under the new law, the prosecutor would have to come up with a specifically identifiable victim. They weren't there to rob you personally. They were there to just take your car. The argument by every defense attorney who walks in that courtroom is going to be, name the person who is in danger because of what my client did. And it's no longer good enough to say, well, the general public's in danger because this person is walking out on the Dan Ryan Expressway, like I saw the other day, reached in their pocket for a gun and made a person get out of their car in traffic and stole their car. Who's the identifiable person? That person's not. The person who stole the car, the criminal defendant, doesn't even know who the driver of the car is. That person's going to be released. And I don't think there's any other way you can read this law other than that person's going to be released. You also have crimes of Class B and Class C misdemeanors. Trespass to property, someone sitting on your porch. Unless they have mental health issues or unless they've threatened you in some way, they cannot be detained. They can't be. They will be released with a notice that says, please come to court. And unless they're a danger to society or mentally ill, the way the law currently reads, the police officer won't even be able to remove them from your porch, hand them their citation, and go about their business. That's going to cause some dangerous situations for everyone. The last thing that I am very concerned about in the Illinois Safety Act is the implementation of two different boards. And these boards are a little unusual. One is the Law Enforcement Training Standards Board, and that is a committee of people who are supposed to set up the standards for law enforcement. On its face, you think, hey, that might be a good idea. Let's have some uniform standards for law enforcement, how they're supposed to act, what they're supposed to do, implementation of discipline. But let's look at it. It's an 18-member board, 12 of them appointed by the governor of the state of Illinois. Another 6 set out by statute of who they have to be. The other board that has been implemented is the Illinois Law Enforcement Certification Review Panel, made up of citizens of the state of Illinois. This is an 11-member board, appointed 3 of which are by the governor and the other 8 by the Illinois Attorney General. That's the people on this board. They're going to receive complaints about officers, for officers, and they're going to make recommendations to the other board. So what's effectively happened is your local boards who handle the safety and discipline of local officers, it's now going to be handled by the governor and the attorney general. So all of this, you say, well, what's this mean to me? What do I care? They've already passed it. What can I do about it? There's actually a lot you can do about it. And you can do it here coming up very quickly. You can go vote. Because at the end of the day, the governor is going to appoint a number of the people to these boards. He already has. And he's got more to appoint. In addition to that, the Attorney General of the state of Illinois is going to appoint another 8 members of the board. These people are going to have control over what happens, how a lot of this is implemented. It's very important that you go vote. In addition to that, they're already talking about, well, we made some mistakes. Well, there's some problems. We're going to have to fix this. We're going to pass a whole bunch of trailer laws, trailer statutes that are going to trail behind the bill and help fix all the places we messed up. That's going to happen in your General Assembly, your state senators, your state representatives. They're going to go vote about these trailer laws. If you go vote here in 2 weeks, you vote those people into office, they have the ability to change this. So all is not lost, but it's going to be very difficult. And it's going to be very difficult to change and very difficult to fix. Because what's effectively happened here is in an attempt to try to make some changes and show the voters that, oh, we've done something. A group of state senators and state representatives rushed through 764 pages of sweeping changes to the Illinois justice system without talking to prosecutors, defense attorneys, law enforcement, or judges, anyone who actually has to do this on a daily basis. And that's the problem with it. And we must stop it. Another change we must have on top of you voting is to push all of your legislators to say, no more 764-page bills. Let's pass bills that are 3 pages, 5 pages, where people can actually read them, know what they say, vote on them individually. And if our public safety isn't worth legislators being in Springfield for a month to pass all these bills individually so that they make sense, so that we can talk about them, so we can have a real debate. Hey, you know what? I like that section. This section's absolutely terrible. Let's try to work these out. Let's pass some that are good. Let's throw out the things that are bad instead of these 764-page massive bills that it's all or nothing. And that's the problem, because public safety is not an all or nothing fact. It is something that, in legislation-wise, needs to be done with compromise, needs to be worked out. And you need to tell your state senators, your state reps, hey, you need to go in there and you need to enact a new statute that says we can't have bills that big. Let's vote on them one at a time. Yeah, it's going to take longer. They're going to have to do their job. And you know what? They get full-time pay. They should go do their jobs. And I think that's where we're at. So what I really ask is, if you have a problem with the Illinois Safety Act, go vote. Because you still can make changes, and you still can change it.